Okay, it looks like we've got the last person that's joined. Good morning, everyone, and welcome to the Canadian Civil Liberties press conference on this anniversary of the invocation of the Emergencies Act. Present today, we have Cara Zwibel, Director of the Fundamental Freedoms Program, Laura Berger, staff lawyer at the CCLA. My name is Alex Nenoff, and I'll be moderating our press conference today. Bonjour à toutes et à tous et bienvenue au point de presse de l'Association canadienne des libertés civiles. Nous sommes ici aujourd'hui à l'anniversaire, à l'insu de l'anniversaire de l'invocation de la loi sur les mesures d'urgence. Et présentes parmi nous sont les maîtres Cara Zwibel, directrice des libertés fondamentales de l'association, ainsi que Laura Berger, avocate avec la CLC. Nous allons commencer avec Cara Zwibel. Cara Zwibel, you have the floor.
Thanks, Alex. Good morning. Today is a sad anniversary for Canada. It was 1 year ago today that the federal government declared a public order emergency in response to highly disruptive but largely nonviolent protests using the extraordinary powers under the Federal Emergencies Act.
Recording in progress.
Under the Federal Emergencies Act for the first time in the Act's history. CCLA quickly challenged the government's decision, seeking judicial review in the federal court. We recently had a victory in that case. Despite strong opposition from the government, the federal court has agreed to consider some evidence that was put before the Public Order Emergency Commission in the judicial review application. We felt it was important to put this evidence before the court so that it would have greater insight into how and why the government made the decision that it did. This evidence had also been made public through the work of the Public Order Emergency Commission. We are looking forward to the hearing of the judicial review on its merits, which is currently scheduled for early April. We also anxiously await the release of the POEC report, which is to be tabled in Parliament next Monday, February 20th. As part of the CCLA's participation as a party in the Public Order Emergency Commission, we made a detailed closing submission, which we are releasing today in our ebook. It lays out our concerns about the declaration, our view that the threshold for using the Act was not met, and our legal analysis of the emergency measures that the government put in place. It will be available for free at ccla.org. I'm going to hand it over to my colleague Laura, and after that, we'll be happy to take your questions.
Maître Berger, à vous la parole.
Parfait, merci beaucoup. Merci tout le monde. Cette journée est un anniversaire assez peu réjouissant pour le Canada. Il y a un an, jour pour jour, le gouvernement fédéral a déclaré l'état d'urgence pour faire face à des manifestations très perturbatrices, certainement, mais non violentes dans l'ensemble. Le gouvernement a utilisé les pouvoirs extraordinaires conférés par la loi sur les mesures d'urgence, une chose qui ne s'était jamais produite depuis l'adoption de cette loi. La CLC a rapidement contesté cette décision gouvernementale et demandé à la Cour fédérale une révision judiciaire. Nous avons récemment remporté une victoire dans cette affaire. Malgré la forte opposition du gouvernement, la Cour fédérale a accepté de prendre en considération durant cette révision judiciaire certains éléments de preuve présentés à la Commission sur l'état d'urgence. Nous estimons qu'il était important de présenter ces éléments à la Cour afin qu'elle ait une meilleure compréhension des raisons qui ont amené le gouvernement à prendre sa décision et de la façon dont celle-ci a été prise. Ces éléments de preuve ont déjà été rendus publics lors d'audiences de la Commission. Nous attendons avec impatience la tenue de l'audience de révision judiciaire sur le fond, qui est prévue pour le début d'avril. Nous attendons aussi avec impatience la publication du rapport de la Commission, qui devrait être présenté au Parlement lundi prochain, le 20 février. La CLC a participé en tant que partie aux audiences de la Commission sur l'état d'urgence. Donc, nous avons préparé un mémoire de clôture détaillé pour en rendre compte. Ce mémoire fait partie d'une publication électronique sortie aujourd'hui. Vous y trouverez l'exposé de nos préoccupations quant à la déclaration de l'état d'urgence, ainsi que notre point de vue selon lequel le seuil requis pour invoquer la loi n'avait pas été atteint, et notre analyse juridique des mesures d'urgence mises en place par le gouvernement. La CLC met cette publication électronique à la disposition du public gratuitement sur notre site web ccla.org. Si vous avez des questions, je me ferai maintenant un plaisir d'y répondre.
Merci, Maître Berger. Thank you, Laura. We're now going to open up the floor to media for a question period. If you do have a question, please raise your hand in the group chat, and then I'll ask you to unmute your microphone, and do also make sure to identify the media agency which you represent. Si vous avez maintenant des questions, nous allons procéder à l'ouverture des micros. S'il vous plaît, vous identifiez en levant la main dans la salle d'attente et j'ouvrirai votre micro en fonction. Okay, we're going to go to Cormac Sweeney.
Hi, sorry, can you hear me okay? Hello?
Yes.
Yes. Okay. All right. Just wanted to make sure. Sorry. Yeah. So, you call it a sad anniversary. I'm wondering, in your opinion, what the lasting impacts of the use of the Emergencies Act in the way that the government used it will be on this country and potential future use of the Emergencies Act.
Yeah, it's a good question. It's a difficult question. I think the answer to some of that will probably depend, frankly, on what we see from the commission. What kind of conclusions the commission comes to about the appropriateness of the use of the act, the legality of the use of the act, the constitutionality of the measures that were put in place. I think also more broadly for some Canadians, the government's use of the act, and I appreciate many people were supportive of the government's decision to use the act. But I think for many people, it was a real turning point, and frankly, a point that really took a group of people that were already facing sort of trust issues with the government and made some of those issues a lot worse. I think that that sort of moment did lead to quite a bit of divisiveness, which was already sort of brewing, and which had already kind of obviously manifested itself in the form of some of the protests. So, I think that may have a longer implication. I also do hope that the government and future governments will look at what's happened here and probably think very, very carefully before using the act again. This was not. I don't think this has been an easy ride for the government. There's been a lot of resources dedicated to answering for this decision, from responding to four applications for judicial review, to answering questions from the media and from Canadians, and of course the whole commission process involved a ton of resources, both from the government in terms of the legal representation that was required to represent the government, all of the government witnesses that had to participate and prepare for the commission. And also, of course, it is government funds that support the work of the commission. So this was a huge outlay of resources. And I think that in itself might have some deterrent effect.
All right. And as a follow-up, we'll sort of double barrel this. We know, sort of what you want the finding to be, but do you... It's almost an impossible thing to answer, but do you have any prediction about where the commissioner may land on the use of the act here? And then also, I know you've talked about this before, but if you could just tell us what recommendations you have moving forward to changing the Emergencies Act legislatively to maybe put more checks and balances and safeguards in place for any possible future use?
Sure. So I won't try to crystal ball gaze about what the commission will find. I do think my impression was that the commissioner did have some questions about the breadth of the orders that were put in place as part of the emergency orders, that there were questions about, whether some form of the protests ought to have been allowed to continue, even if the most disruptive and the parts involving vehicles had to come to an end. I also think that the commissioner struggled with the fact that the government was relying on a legal opinion that it would not share with the commission. So I think that might be a very significant piece of what the commissioner has to say, that, his work was hampered a bit by not having that opinion. In terms of recommendations going forward, we are not proposing that the threshold for invoking the act change. We think the threshold is high. We just don't believe it was met in this case. But some of the recommendations that we do think are worth exploring have to do, first of all, with the work of the commission. So giving it a little bit more time to do its work, because it was a pretty, breakneck case that the commission had to work under. I think there might also be some value in dictating, frankly, what kind of disclosure obligations the federal government has in these accountability processes. That the act is built with these very important and presumably robust accountability mechanisms, like the parliamentary committee, the requirement for an inquiry, the requirement to table reasons before Parliament. But then the government still has all of its sort of common law privileges, where it says, this is cabinet confidentiality, we won't disclose this. We have solicitor-client privilege over the legal opinion, we won't disclose that. And, broadly speaking, all of those privileges are important. They have value and there are reasons for them. But in the very particular circumstances of using this extraordinary legislation, where we're trying to get real accountability and transparency over what motivated the government, I think that we need to look at creating some clearer rules around what the government is going to be expected to hand over. In the commission process, I think there were certainly still disclosure issues and problems, but there was a lot of information that the government put out that we wouldn't normally have access to. In the judicial review, the government has been frankly, very difficult in terms of what it's willing to sort of put in the record before the judge. And we've just had this argument. We've put a motion forward, and we were successful in getting the federal court to consider some of the commission evidence. The government resisted that strongly, but now that they've lost that motion, they're bringing their own motion to try to get some other commission evidence in, which we are resisting, because we were quite narrow in what we asked the court to look at. Things that were really before cabinet when the decision was made. The government is now asking for some of the commission evidence to come in, which is really sort of trying to bootstrap after the fact about, why the government did what it did. So all of those sort of legal games that are happening, I think, could be addressed by some amendments to the Emergencies Act.
Thank you. We're now going to go to Rachel Aiello. Global News.
Hi.
Rachel.
Thanks. I'm with CTV. So firstly, just on the occasion, that's okay. On the anniversary today, there really is not much planned on the Hill. It doesn't seem like any politician is going to be quick to acknowledge this anniversary. Does that surprise you?
Not really. I mean, I think this is probably something that most would probably prefer to forget. I think even the members of Parliament that were opposed to the use of the Emergencies Act recognize that it may not be the most popular position to have opposed it. And so, there is some value to leaving well enough alone and moving on. I think it's important to acknowledge, not only because it was a significant event in Canada, but also because, in a week we're going to get some answers from the commission about what, after what I think was a fairly thorough independent review, what that body has determined. So, but I'm not too surprised that people aren't marking the occasion.
Right. And just with the commission report coming, presumably there's going to be a conversation after that about potentially amending the Emergencies Act, making changes to the legislation. Is that something you would advocate for, or what advice would you have to parliamentarians if they do decide to embark on that task?
Yeah, so like I said, I think that there's some value to some targeted amendments around some of the accountability pieces of the act. We are not proposing that the government amend the legal threshold for invoking the act. I would anticipate that if the government, if the commission, for example, decides that the threshold wasn't met, I would imagine that the government will want to bring in amendments that would make it abundantly clear that they could use the act in circumstances like this. But those are not changes that we think are necessary or appropriate. It's not only that we think the legal threshold wasn't met in this case, it's also that we don't think this case was a case that justified the use of emergency powers.
All right. I guess we'll go to Milan avec la presse.
Sorry, Alex, I think you're cutting out a bit, but I think it's Mylène with La Presse. If you,
Oui. Est-ce que vous m'entendez?
Oui.
Can you hear me? Yes. You mentioned the legal advice the government had.
Sorry, now we're having trouble hearing you.
Can you hear me well?
Now I can hear you, yes.
Okay. I'm in the basement of Parliament, so that may explain it. You mentioned the legal advice that the government had to invoke the Emergencies Act. I was wondering if that's something you think will come up in your court challenge. Like, is that the kind of document that the government would have to, I guess, divulge at that point?
No, I mean, we're obviously almost a year from when we launched our application for judicial review. And so the fact that we're still having debates and discussions with the government about what the record is for the judicial review to consider is a problem from our perspective. And the legal opinion is not something that we would expect the government to waive privilege over, and it's not something that we would expect the federal court to review or require them to waive privilege over. And I think actually in the context of the judicial review, that's less problematic than it is in the context of the commission's work. The judicial review is supposed to sort of look at the information that cabinet had when it made the decision, and obviously the legal opinion is a piece of that. But really, what we're asking the federal court to do is provide its legal opinion on whether that threshold was met. And so, I don't expect that the legal opinion will be part of the judicial review. And certainly, I think if the government refused to waive privilege over that opinion before the commission, they would not take a different position in the judicial review application.
I see. I was wondering, is that something that is done usually? Like, do do you remember other cases where the government would have waived the privilege on legal advice like that?
No, I mean, it would be very unusual for the government to waive a privilege over the advice it gets from its lawyers, from the Department of Justice. That is not something that they would generally be willing to disclose. I think, in this case, because of the extraordinary nature of the use of the act and the fact that the act was constructed in a way to try to get sort of, at least after the fact, transparency and accountability, that we do think there was a good justification for waiving the privilege in this case, but it's not something the government was willing to do.
Okay, thank you.
I don't know if Alex is having. I'm not sure if Alex is having.
Yeah, no, I'm just. Is there questions? Or can you hear me?
You're cutting in and out again. I don't see any more hands though. So, on the assumption that there are no more questions, I hear someone talking, but it's cutting in and out.
No more.
Oh, okay. I see. I think Cormac McSweeney. I see your hand again.
Yes, I think Marlene with La Presse has also got her hand up as well after this. But I'm just, memories of viewers and listeners can sometimes be rather short, and people forget. As you pointed out, a lot of people say, yeah, we did agree with the use of the Emergencies Act. A lot of polls have showed that most Canadians believe it was the proper thing to do given the circumstances. Can you just go over again? And I know you've gone through this many times over the last year, but can you go over again why you have problems with the use of the Emergencies Act to deal with the convoy protest as the Emergencies Act was used?
Sure. So the Emergencies Act has, it has a few different sort of thresholds, and there are several different kinds of emergencies that are contemplated in the Act. The type of emergency that was declared in this case was a public order emergency, and for something to be a public order emergency, there has to be a threat to the security of Canada that rises to the level of a national emergency, and a national emergency has its own sort of definition in the Emergencies Act. But that first piece, the threat to the security of Canada, in the Emergencies Act is defined by referencing the CCIS Act and the definition of that phrase in the CCIS Act. And in the CCIS Act, that phrase is defined with reference to things like, sabotage or espionage, or acts or threats of serious violence to persons or property. So there's a few different pieces. I don't have it in front of me right at this moment, but there's a few different pieces there. And at the time that the emergency was invoked, we had not seen acts or threats of serious acts of violence against persons. There was of course the concern in Coutts, Alberta, with the individuals who were arrested and had a cache of weapons. Those people were arrested before the emergency was declared. That situation was addressed before the emergency was declared. And beyond that, when the government, put forward its reasons, which it had to do to put to Parliament, those reasons also didn't really specify any threat of violence or acts of violence that had been committed or were expected to be committed. It talked in sort of vague and speculative terms about what might happen. But our view was that's really not, just sort of speculation or concern about what might happen is not enough to use the Act. When the Act was drafted, it was a deliberate decision to reference the CCIS definition, and the government, before the Commission, took the position that even though the definition referred to the CCLA Act, there were other considerations that applied in this different context, and really that they could sort of take a broader understanding. The other pieces in the Emergencies Act that are important thresholds in defining what is a national emergency is something that can't be dealt with by the ordinary, laws in place either federally or in the provinces. And there again, we don't feel that threshold was met. We do have, and we, across the country, police services deal with disruptive protests on a regular basis. We have legal tools to do that. Some of those tools were used, in this case before the emergency was invoked. So there were injunctions that were used in Windsor, and eventually in Ottawa. There are police powers that can be used. There was a resource problem and a coordination problem in terms of addressing what was happening on the ground, and that took some time for the various police services and jurisdictions to coordinate and work together on. But it wasn't a situation where we didn't have the laws that we needed, and really that, in our view, is what the Emergencies Act is for. It's when we don't have the tools, and in our view, we did have the tools. The government and police services did have the tools to address that. So those are some of the concerns. There are also concerns with the emergency orders that put in place, and the breadth of those. We had, by the time the emergency was declared, we had some specific locales that were still of concern, but these orders applied across the entire country to every Canadian. They involved, severe restrictions on the freedom to peacefully assemble. They involved the possibility of having your, personal assets frozen with no notice and no due process. And those are extraordinary powers that there is a good reason why we set a high threshold in the Act. And so those are some of the reasons why we don't feel they were met.
No follow-up for me. I'll just pass it off to Mylène then.
Okay. Mylène, do you still have a question, or is your hand just still up from last time?
I think it's still up.
Okay.
Thank you.
Okay. So then I don't see any others, and I know Alex is having some connectivity issues. So I think we will end it there, and I will just thank you all again for joining us this morning, and let you know that if you want to take a look at the ebook, it will be on our website, ccla.org. And I'm sure I'll be speaking to many of you again next week after we see what the Commission has to say. And I want to thank my colleague Laura for joining me.
Thank you, everyone. This concludes our press conference. I'm sorry if this is still choppy, but merci à toutes et à tous de votre participation. Bonne journée.